Computer. Wajari Gamawara. Before we begin, I'd like to acknowledge the traditional owners of the land on which I stand today, so the Bedegal people of the Eora Nation. I'd also like to pay my respects to their elders, both past and present. As we come together in this place of learning to grow and share knowledge, may we always remember the Aboriginal custodianship of country embedded in the land forever. Good evening, everyone, and welcome to the client interviewing demonstration. Tonight, we've got Alison, who will be acting as our client, Paula Ennis, and myself and Harry will be the solicitors for this demonstration. Thanks so much for everyone who's tuning in to watch tonight. So tonight we'll be demonstrating a client interview, which is a 30-minute session in which two solicitors interview a client. It's a great way to apply your legal knowledge in a practical sense and really challenge yourself in your degree. And we really encourage everyone to get involved this coming semester. Internal competitions are now also open to everyone, and for the moots, we have the Streetons Criminal Law Moot, the Herbert Smith Freehills Contract Law Moot, and the First Year Moot running in semester 2. And in our skills competitions, we'll be running the witness examination, the King and Wood Mallison's client interviewing, which we'll be demonstrating, and the Clayton Utz negotiations. And the client interview and the negotiations will have a senior and junior division as well. Please see our SOLS Competitions YouTube page, YouTube channel for witness examination demonstration, as we can't really show it virtually, but we are going to be having the client interviewing demonstration tonight, and the junior negotiations grand final will be tomorrow if you'd like to see that competition in action. All right, without further ado, we might as well get started. So let me pull up my timer. Okay, whenever we're ready.
Hello, Paula. I'm Harry.
My name is Sarah. It's very nice to meet you.
Hi, thanks for meeting with me today.
We're from Sydney and Law Associates & Co. Thanks so much for making it to our online consultation today. As I'm sure you're aware, we've booked in for a half-hour consultation today, which is going to be free of charge. In terms of how this online consultation is going to run, we'll have a few housekeeping matters that Harry's going to quickly run through after this. And then after that, we'll give you an opportunity for you to tell us why you've come to see us today. I'm sure we've probably got a couple of questions to gather a bit more understanding as to the situation you found yourself in. And then after this, we can offer you some preliminary advice. I would just stress that this is going to be subject to collecting more information and further research, but we can just give you an idea of where to go from here and how we can help you. So if at any point you don't understand anything or we're moving a little bit too fast, please don't hesitate to stop us and ask what that means, and we can slow down and clarify things. How does that sound?
Yeah, well, obviously I came here today and I'm demanding that justice be served because I think that I've been ripped off by some really, really shady people, and I'm hoping that you guys can actually help me because I've dealt with so many awful people and I need to be able to get justice, and I deserve high quality legal representation, and I expect nothing less from either of you.
Well, we definitely hear that, Paula. And again, we'll listen to your concerns in a moment as well. But as Sarah said, I do have to go through some housekeeping as well. But as soon as that's over, we're more than happy to accommodate and to hear your concerns as well. But with that said, in terms of housekeeping, the first thing that we need to get out of the way is our retainer. So as Sarah said, this initial consultation is free. However, just to be clear, our ability to take actions on the things we discussed today is contingent on whether or not you retain us and use our services further. Our secretary will email you our retainer following this interview. You can also find our contact details and the details of the firm at the end of the document. Again, if you have any questions, feel free to contact us. So the second housekeeping pertains to confidentiality. So anything that you say here and any notes that we take is privileged and protected. There might be a few instances where we might need to break confidentiality, but if we're approaching the area, we'll stop you, warn you, and you can make the choice to continue on or not. Furthermore, we take your privacy very seriously and have taken precautions to make sure that our Zoom is protected and is not being recorded for your privacy. Lastly, the final housekeeping matter is that if any conflict of interest does arise, so for example, we represent a client which is also party to your issue, we may not be able to act for you, but we can refer you to someone who can put your interests best at heart. If a preliminary check doesn't give rise to any of these issues, but if you notice anything, please stop us and we'll take appropriate action then. Now that we're going out of the way, could you please tell us a bit about why you come today?
Well, I own and operate my own skincare company. I've done it for a year. It's called Wrinkles Be Gone Limited, and it focuses on the invention, development and manufacture of luxury, high-end anti-aging products. And because this product is so amazing and it's gotten these amazing reviews, I've been seeking to, well, I guess sell it more, because which businesswoman wouldn't want to sell more? So I've been wanting to get to high-end department stores such as Devinda Jonas, and because all my products are so amazing and they're so original, they will receive these really good patents. And I have this really new cream. It's called the Rat Wrinkle Ritter. Now, I know you guys probably think that sounds awful, but let me tell you, this product is game changing. And the secret ingredient, rat urine. You probably think that's disgusting, but it reverses the aging process like no other cream on the market does. And I don't even know if you actually appreciate how good this cream is. It's really good. And I've had a patient for this product as well because of how amazing it is.
Awesome. Well, it's so good to hear that, you know, as a successful businesswoman, you've been really powering through and getting all of that done. Can you tell us a little bit more about this cream and when it was first developed?
Well, it was developed 6 months ago, and my amazing team and my amazing scientists have shown that, have managed to find that rat urine is quite potent in terms of reversing anti-aging. And there's never been a cream like this, and no one has actually suffered any short-term side effects. And because of that, we got a patent, and you know, we're getting large-scale manufacturing, getting it out there, getting out to the department stores. And I started contacting Devinda Jonas because, you know, big department store, amazing product, who wouldn't want it? So they really wanted to sell this Rat Wrinkle Ritter, which I'm going to call RRR because it sounds so much cooler. But we had decided that obviously there was going to be a few conditions because I have to protect my business.
With that said, I'll just take us a little bit back and also ask, do you know which patent did you file for?
I filed a standard patent.
Okay, thank you for that.
And I thought that would be pretty obvious if you guys were good lawyers.
We just want that we clarify everything and make sure that we have everything written down so we're not missing anything. And that's just why we're asking these questions, to be very, to just really step through everything and make sure that we haven't missed anything. In terms of the patent, can you give us a little bit more details, if there's any specific terms or anything attached to it that we should know about?
Well, because it's my own product, and because I have a patent, no one else can actually make it or sell it, hire or dispose of the product. So, you know, it's my business, my product. I get all the rights.
And with that said, we did notice that you said that it took approximately 6 months for you to create your product. Could you step us through that process?
I didn't say that. I said that it was developed 6 months ago.
Oh, okay. Could you give us an indication about how long it took for you to develop that product? And sorry for that.
Well, that's not really relevant because we developed it 6 months ago and it was already manufactured 4 months ago and was being sold at Devinda Jonas. So it happened pretty quickly.
So to clarify, it was being sold at Devinda Jonas 4 months ago?
Yeah.
Okay, so it took 2 months from the development stage to being on the shelf.
Yeah.
Perfect.
I guess.
So you talked about a contract with Devinda Jonas to essentially sell your products. When did you sign this contract?
Well, it was signed 5 months ago. And yeah, they're really happy to sign, and because this product's so amazing.
Yeah, we totally understand. We're sure that it's a fantastic product. In terms of the actual contract, were there any specific terms or conditions attached to it that you think would be relevant to any of your issues?
Well, the agreement was exclusive, and so that means that RRR can't be sold by any other store.
Perfect. And is there any room for renegotiation in this contract, or is there anything that you're unhappy with in terms of the contract with Devinda Jonas that we should know about?
No, because I've been having these amazing sales and like really amazing profits that I've been getting and Devinda Jonas has been getting, and you know, my product's been so amazing that I've been appearing in these popular magazines, including in Female Fortnightly, and Myers wants to try and get my product because they're jealous of the success that I'm getting and that Devinda Jonas is getting. But you know, I had a contract already and I wasn't going to break that. And I said, no, you're not taking it. Davinda Jones has it.
Well, thank you so much for that. And before we move on to the next line of questioning, we'd just like to ask if we could get a copy of that contract. And I think that'll be really useful for us to just really go through those terms, just to make sure that everything is airtight. Is that okay with you?
I'll have to ask my secretary about that.
Okay, that's
That's
more
not
than
something I look after.
That's more than fine. But with that said, could we start looking at why do you think, the question is in terms of Myers, and what about Myers did you really want us to pursue? So what's your goals and expectations in regards to that?
Well, what I've heard is that Myers is trying to copy my product, and they're because they're jealous of my profits and they're jealous of how successful I am. So they're trying to make a new home brand product which checks the RRR stuff. So, and they're trying to claim it, essentially claim my business and my profits by trying to copy me.
Could you give us an indication about how you know there is some sort of copying involved?
Well, I have sources, and like Myers shouldn't be able to sell my product because it's mine. Like, there are tangible legal solutions to stop them from doing that, and I'm demanding that you guys get that for me.
Yeah, so I'm just going to jump in here and manage your expectations by saying, well, we most certainly can place you in the best legal position, but we're just asking these questions just so we can get as much information as we can to, again, assess your situation and then place you in the best position. So in no way, shape or form are these questions designed to attack you, but again, it's just to get much more information from you, if that makes sense. But with that said, could you elaborate a little bit more on what your source has described to you?
Well, I said I have multiple reputable sources, and because I have connections, I know what's happening.
Can you give us a little bit more detail about who these multiple reputable sources are and how you know them?
Well, I have employees that work part-time for me, and they also work part-time for the Myers product development team, and they've given me these scientific documents that demonstrate rat urine in their cream, and they want to sell a product as a cheap home brand product of their own, and they're essentially just taking away all the success I had because my company was the one who came up with this first.
I definitely hear your concerns, and it does.
Yeah, there's no reason that Myers should be able to sell this product. Do you know what I mean? They're trying to copy it, and they're trying to take my success. And do you know who I am?
Yes, we're really aware that Myers, it seems like Myers is trying to imitate your products, and that's definitely not okay from a legal point as well, and that's something that we'll be addressing. But we just want to step through all of these questions and just make sure that we have all of the available facts to us so that we'll be able to place you in the best position so that we can get the outcomes that you want. So just addressing that, did you know that your employees, the part-time employees that you were mentioning, also worked at Myers as well?
Yeah. It's pretty normal.
Okay, so was Myers also aware of that, that they worked with you?
I don't know what Myers is doing, but all I know is that they're doing shady stuff and there's tangible legal solutions to stop them from doing that shady stuff.
And again, we can understand, and we hear that you are really vouching for these tangible solutions. And again, we'll come to them in a moment. But you are correct in that regard. Subject to a little bit more research, we can provide you with some really tangible and realistic solutions. But with that said, we just have a few more questions about the similarity.
I've already said they're basically trying to copy my product, and I should be able to get legal solutions for them trying to copy my product. Why are you still trying to ask these questions?
Yeah, so we just do need a bit more information, and we do understand that what may seem very obvious to you might not be as obvious to us because we haven't heard everything that has been going on. So we're just trying to get a scope of what has been happening so that we'll be able to answer those questions and to help you. So in terms of you've been mentioning a couple of times these tangible legal solutions. What kind of solutions are you after specifically?
Well, I'm surprised that you guys as lawyers don't have an idea, but I'm seeking restrictive injunctions so that Myers can't sell my product.
Okay, well, it's good to hear what you're expecting and how we can help you there. And a restrictive injunction is definitely something that we can look into and to support.
I don't need you guys to look into it. I know you can do it.
So just to manage your expectations, there is a process for us to submit and file that application. But again, subject to further research. But in order for that to be done, there still needs to be steps for us to go through. But that's definitely something that we can look in for you. And again, that's definitely on the table. However, we were also wondering if you had any goals and expectations in terms of your reputation, given that you were a part of the fortnightly coverage, and we wanted to see whether or not, is there anything else that you would like to pursue in terms of that?
Well, I've obviously had an amazing business, an amazing career, an amazing product that no one has ever made before. And I don't want people to be stealing my product. I don't want people to think that they can get away with that. And I want them to know that I have been a successful entrepreneur and an influential businesswoman. And that's something that people should be recognizing and not trying to steal from me.
And we can definitely hear that, and we can definitely empathize with that as well. Sarah, did you have any other questions?
Yeah, just in regarding the cream that Myers has been copying essentially. Do you know when that is going to be released?
Well, I don't know yet, but I would suspect that they're doing it pretty soon, which is why I need a restrictive injunction to stop them from trying to steal my money.
Yeah, we definitely hear you. And so they are currently working on that cream, is that correct?
Yeah, well, they're trying to sell it as a cheap sort of like rip-off.
Do you know when they started to develop this?
My sources haven't told me, but all I know, I don't think that really matters. All that really matters is that I got the patent and this is my product and they shouldn't be stealing it and I should be getting good legal representation.
Mm-hmm. We definitely hear you there. So I guess just moving on in terms of how we can help you address those issues and those questions. First, on the point of the patent, obviously we'd need to know what exactly the terms of those patent is. So
it's an exclusive patent. It's a standard patent. It's just a standard patent. Why is that a question?
Well, to put it into context, what we do need to know is what exactly is patented. So if that's the ingredients or if that's the branding or things like that, because that will affect how we'll be able to approach Myers and see where that imitation is coming from. For example, if it's coming from the ingredients, so the specific rat urine section, then that's a lot more approachable in terms of the ingredients lists, and we can compare that. Whereas if it's from a branding perspective, that might be a little bit more difficult. So we just need a little bit more in terms of the particulars there. And I think you know that we could get that from your secretary. So that is something that we'll be requiring after our consultation.
So just to jump in here and really then to address something that you mentioned earlier about a restrictive injunction, that then, as Sarah said, will help us then file such a claim. And what that really looks at is seeking an injunction from the court, restraining Myers from reproducing your work that you've worked very, very hard to achieve. You could seek an order from the court and we could then enter into Myers' premises to really seize the offending material. As you stated, they're using the same ingredients. Alternatively, and just so that you're aware of all the other options that are available to you, we could also file a claim for damages, which then will allow you to have an entitlement to the profits or the delivery of the infringing articles. Does that make sense?
Yeah, but I just do the bloody restrictive injunction. Like, it shouldn't be that hard.
That is our aim, and that is what we're going to be looking at. But I think just to manage your expectations, the amount of time that it takes to get a restrictive injunction could be a week or two. So obviously, the sooner that we get these documents, so the sooner we get a copy of your exclusivity contract with Davinder Jones, as well as a copy of what is actually patented, the sooner we'll be able to turn this around and get an injunction in play. But like Harry mentioned, the damages and things like that are a backup in case that doesn't go through, because that is subject to whatever the court decides. And if the injunction doesn't go through and that's the case, then there are other alternatives that we can reach. So like Harry mentioned, the damages is something that we could potentially look at. And even before getting an injunction, we could also have a look at negotiating with Myers and seeing seeing where they are in terms of their production and in terms of their imitation of your product, and seeing if there's any way that we can talk with them and see if there's any other options available for both of you on the table.
How does that sound?
Yeah, well, I just need a restrictive injunction. Like, that's the thing I need.
So really what we understand, what we hear from you is that the purpose of this restrictive injunction is to stop the imitation of your product.
And you can't guarantee that I can get a restrictive injunction?
No, well, the answer to that question would be, again, subject to further research in what's within your contract. However, what we can say is that there are alternative ways for you to achieve that outcome, to stop this imitation. So as Sarah correctly has identified, potentially there's also a way for us to mediate and negotiate with Myers to really ascertain about their production line. And more importantly, potentially, if you're interested, for us to control how the narrative and control what is happening behind the scenes. With that said, we are very cognizant that you are a reputable, successful businesswoman, and we would like then to really maintain the partnerships that you have existing with Davina Jones, but also potentially with Myers in the future as well. So this is just basically future-proofing and ensuring that you have an amicable relationship between these entities and these parties, so we can then maintain your image as a successful businesswoman.
Mm-hmm. And just to piggyback off that and explain a bit more where Harry is coming from, we're really not only thinking about the short-term goals of obviously the injunction that you want, but also in the long term, over the 10, 20-year mark, where exactly your business is going to go. So we just want to leave all options open to you in case you do ever want to work with Myers again, maybe in a more official capacity, or renegotiate your contract with Davina Jones. That is all available to you. And so that's where we're really coming from, to be able to put you in the best position so that you're future-proofing your business as well. Does that make sense?
Yeah, well, I just need this to get done. I just need Myers not to steal my stuff or steal my products, and I need justice to be served. And I better get justice now, otherwise there's going to be consequences.
Mm-hmm.
Well, we definitely, sorry
Harry. We are trying to put you in the best position possible, and that's our goal here always as lawyers, to be able to help you and support you in whatever you wish to do.
But with that said, I think there are some concerns that we would like to raise moving forward. We spoke about earlier a bit about your sources that come from both Myers and Davina Jones, and potentially there are employees that work for both. And we would just like to really reinforce the fact that potentially that presents some moral or legal issue due to a conflict of interest or confidentiality, reasons of confidentiality. So we would like to say to keep these communications strictly between ourselves and with Myers, just so that we aren't running into miscommunications, and so that we are presenting a united front.
Mm-hmm. So in terms of a couple of things then that we'd like you to do for us is we want the contact details of those part-time workers that you'd mentioned, as well as any other details that they can provide for us in terms of what Myers has done and what you know. We'd also need the specific documentation and the copy of the patent when you have that from your secretary, as well as a copy of the contract that you've signed with Davina Jones for the exclusivity agreement.
How does that sound, Paula?
Yeah, well, I can definitely get that to you, as long as it means that I can get their injunction and I can get what I need.
Yeah. Well, that's definitely our first goal.
And again, just to reiterate, we will be putting that your best interest at the back of our mind as well. One last thing that we would like to potentially suggest is potentially then trying to remarket your product and potentially rebrand it, so then we can retain its superiority within the market and its market share, given that it's the first of its kind. And again, potentially you're interested in doing so, and we can later discuss this as well, as Sarah said, so then we can maintain your success, not only in the short term, but also in the long term as well, as potential suggestion that we might provide here.
How does that sound?
Well, as long as it doesn't mean that I start losing money, and as long as I keep my clients, we'll see.
Okay, well, we definitely hear your concerns, and that's at the forefront of our minds as well in terms of how we can help your business get through this troubling time. So I guess, Harry, would you like to outline a couple of actions that we'll take then on your behalf, Paula? So when we next come back, we can put things in motion.
So as we spoke about at the beginning of this consultation, our secretary will send through our retainer, and again, that will have our contact details. So if you have any questions, feel free to then contact us. But with that said, we'll also be sending or preparing a letter of demand to Myers to cease production and or imitation of your product of any kind. And that will then give us scope to ensure that they don't continue their development. We will also then send this all via email, so you don't have to copy or be overwhelmed with anything that we say today, through a letter of advice, which then will detail the relevant legislation and also to detail the steps of how we're going to achieve this restrictive injunction on your behalf. And on top of that, we will, the letter of advice will detail all the concerns that you've come in today with.
Wonderful. Paula, did you have any other concerns that we can help you with today?
I just need this injunction, and I need to maintain my reputation because I spent so long making this business, and I can't have lawyers like you guys ruining it. So you better get what I want.
Look, we're definitely hearing you, and we're putting your best interests at heart. We understand that you want this injunction, and that is our first goal. So as soon as we get that information, we can start working towards that goal together. So we'll send you out an email just confirming everything that we spoke about today, and just reiterating those next steps that Harry outlined, and the actions that you should take, and how else we can assist you there. And so once you've received that email, if you have any further questions, please don't hesitate to come back and talk to us. Thanks so much for meeting with us today, Paula. We really hope to hear from you soon.
Thank you so much.
Thank you.
Awesome. Wonderful.
Right, so that was a demo negotiation. Very well done to Sarah and Harry for dealing with a very aggressive caller. If you guys have seen the facts, well, there's a specific instruction on character, and she is told to basically be stuck up and cultivated and shade lawyers and intimidate them a fair bit. So in terms of questions, we have had a few that have been submitted earlier, but if you guys have any questions, feel free to drop it in the chat. Then Sarah and Harry can answer them for you. So I guess probably one of the first questions that first-time client interviewers have is, what's the general structure of a client interview?
Yeah, so I would say in terms of the general structure, we always start with an opening and an introduction. So you might have noticed Harry and I had a little spiel at the beginning where we talked about the confidentiality, things like how we're going to progress if there are conflict of interests, things like that, and those kind of housekeeping matters. And those are the things that we address just so we get them out of the way. And then the next thing that we move on to is really the questions, and asking questions to the client and seeing how else we can tease out their story to be able to listen, to get out those secret facts that are hidden from us until we ask those questions. And then the last 13 to 15 minutes or so would be addressing the client's issues. So addressing them in terms of what can we offer to them that will make them walk away and feel like they've gotten something out of the interview, whether that's, an offer to negotiate. We understood today Paula really wanted a restrictive injunction, so we told her a little bit more about that process, and we said we managed her expectations in terms of it's going to take a week or two to get this. So the earlier you come back to us with the list of things that you're going to do, the sooner we can turn that around for you.
No, I definitely agree. But I think we also very cognizant of the personality of Paula or Alison in this context, and making sure that we're responding to her needs throughout the entire interview and not just in the question time or at the end as well.
Yeah, I do have to say Paula was quite aggressive most of the time, which makes it difficult as solicitors as well. And I guess, how do you guys prepare for a client interview, and what makes it different for like competition that's online compared to like one that's in person?
Yeah, definitely. So in terms of prep for the actual interview, Harry and I, we only get to see the memo that's prepared. So if you saw on the Facebook event, there was the memo was put up, and that's all that the solicitors get. And then from there, you kind of have to look at those issues that are outlined. So in this case, the memo outlined a couple of issues in terms of her company. She said something about a patent and an invention. So from there, we're kind of having a look at and doing research about patents and seeing what type of patents are out there, if it's a standard patent, if it's an innovation patent, those kinds of things. And then asking those questions and coming pre-prepared with those questions, because we know that we'll definitely need to know the answer to that to be able to address her questions and to address her concerns later on.
However, we also try to keep the questions quite open as well, and our research really open, just so we don't approach that interview with a closed mindset, or at least a pre-assumption. And if, let's say, Paula or Alison speaks about something that we don't actually quite understand, it's actually okay for us to say that it's subject to a little bit more research, given that we're not supposed to know everything in that moment as well.
And in terms of preparing online and via Zoom, Harry and I have actually put together a kind of document, and I'll just share my screen for a second to show you what that looks like. So how we usually structure our things is we like to have the issues outlined and the questions that we're going to ask. And then it's followed by the action items, so the things that we're going to say, and all of this is pre-prepared. And then our alternative courses of action. So, and then our conclusion as well, to say, you know, what are we going to say, and then what are we going to ask them to bring next time to the table.
Looks very comprehensive. So I guess building off what you guys have asked, another really common question that's often asked in terms of like skills competitions specifically is, do I need to have studied any subjects, and will that detriment me if I haven't studied specific subjects?
Harry, do you want to address this one?
I think the answer to that is no, because I think the really major skill that you really need to exercise here is active listening, and really to empathize with your client and ascertain what their goals and expectations are. For us at least, sometimes we stumble upon topics or issues that we haven't learned yet, given that we're only in our third year. But really, what it comes down to is us trying to understand what the legal position is, what research we need to take beyond the interview, and then trying to then construct a cohesive, structured response so that they can leave the interview feeling confident. But to answer that question, do I need to know specific topics? The answer is probably not. Cheryl, do you agree, or?
Yeah, definitely. I think it's something that everyone can kind of walk into, even if you don't do as much research, because a lot of it is based on what the client is telling you. And really, if you have a look at the marking score sheet and the marking criteria, a lot of it is based off how you're managing those client expectations, how you're making them, like if you're leaving them satisfied at the end of the interview, and whether they're happy with what you're saying. So rather than specifically the advice that you're giving them, it's more about how, in terms of how you can make them feel like you've addressed their questions and you're going to do something about their problems. So you're not just going to leave them alone. You're going to be very active in following up and answering their problems for them.
The only caveat to that would probably be that we would do a general research, again, as Sarah said, based on the memo that we received at the very beginning, just so we know the keywords there and trying to suss out like the general legislation, or at least the general issues that might come up with that particular word, and then we move from there.
But in terms of prep time and, you know, amount of hours that you're going to put to it, it's definitely a lot less than the other competitions like mooting or like client interview, or like negotiations. Client interviewing is much less. I would say we probably put in like maximum an hour of prep into each round that we do. Which is always a plus.
A plus when you are tight on your schedule. Yeah, just a reminder that unfortunately you cannot unmute your mics. So if you have any questions, feel free to drop them in the chat and we will get to them. Another common question that gets asked is, what if I don't know how to answer the client's questions on the spot?
Well, if you're not sure like how to address those clients' questions on the spot, you can always refer back to, we'll need to do more legal research on this, and we'll just need to be a lot more clear on what the law is before we can actually address those questions. So when Alison or Paula tonight was talking about restrictive injunctions, we didn't have all the information. We're not experts on these kinds of injunctions and things like that, but we just had a little bit of information that we knew, or things we had heard or picked up from either research or just from general knowledge, and we were able to put that together and address her questions there. But even if we didn't know, we could have just said that subject to further research, and that's something that we'll address in our letter of advice, right? And that's why we always suggest in an actions for us kind of section, at the end when you're concluding, it's always good to say, we'll put together a letter of advice detailing any legislation, any other things that we think could be relevant to you, and we'll send that to you as an action for us to do.
And on the other extreme, then just to jump in, I think we would caution against saying quite affirmative statements where you don't necessarily know if it's right or wrong. So then promising Alison then or Paula that we are going to be able to achieve, or at least get a restrictive injunction or any of the other legal terms without our full knowledge, that's potentially a little bit more detrimental, because then you're not really managing the expectations of your client very well, and we might be promising something that we can't necessarily do anyway. So for us, it's safer for us then to really come back and take a step back and actually try to assess the issue objectively, rather than catering to their emotional needs in that very, very moment, in terms of giving them a specific legal answer.
And I think one way to address that is just to say, look, we hear what you're saying and we understand where you're coming from, and all we can promise is that we're going to put your best interests at heart. We're going to do our very best, and that's all we can promise, right? Because if you're thinking in terms of actual solicitors that do this, then they also have obligations to themselves and to their other clients as well. They can't just drop everything for this one client. So you have to think in terms of, how do you manage that expectation realistically? Because this is supposed to be a mock realistic interview.
Yeah, that's definitely really important. And definitely in that interview when Paula was continuously pushing for a restrictive injunction, it's quite challenging for both of you guys. So we do have a question about the structure of the client interviewing with the 2 lines of questioning. So do you firstly have general questions and then focus more on the client's issues, and then do you provide solutions after that?
Yeah, so I think in terms of how we kind of address it is, we first let the client talk about everything that they've said, or their story first, to get out the beginning of that story and that information. And then we start with more open-ended questions to be able to funnel that into the close-ended questions. So starting with things like, when was this developed? Or like, can you tell us a little bit more about this cream, about the timeline of events? And then funneling that down very specifically into, what kind of patent did you get? What are the specific terms of the patent? Was this disclosed to Daviana Jones, for example? So really working from that broad spectrum down to more narrower questions.
And we always like to give the client a chance to speak at the very beginning, just so that we can assess how many issues or sub-issues there are as well. But what might be really interesting is that once the client has given their overview of information, for you to give a general outline about what those issues are and to confirm it with them. And what will that do? And that will assist you then in structuring the interview by going, okay, we understand this is to be your first issue. Once we finish all those questions in terms of that, we can signpost by saying, okay, well, if you have no other information to state about that, we can move on to the second issue. And that then gives the client confidence and at least knowledge about where they're at in the interview at all times as well. But using the open, then funneling down to close-ended questions.
Mm-hmm. And then after you've done all of that, and once you've recapped where your client is at in terms of their situation, and that should take you 15, 16, 17 minutes potentially. And then after that, you move into those other alternative courses of action and how else you can help and support them.
Sounds good. And I guess building off that question, what are some strategies that have worked for you both in terms of interviewing clients.
I think the biggest thing that I've learned throughout all this is you have to listen to what your client is saying, and listen to not just what they're saying physically and verbally, but also what their body language is saying too, right? So when this was in person, of course, a lot of people were expressing different things with their body language, and you could really tell if they were comfortable, if they were uncomfortable, if they didn't want that kind of solution that you were offering, in which case you could quickly backtrack and say, actually, it doesn't look like you're very comfortable with that. This might be a better option for you instead.
In terms of that, I definitely agree. The two things that really come to mind very quickly is one, your teamwork, whether it be online or face-to-face. I think that being able to trust and rely on your partner in understanding when they need help or when they want to jump in, that's really, really important, because then you're able to bounce off each other and really demonstrate that you guys are in there and addressing the client's need together. And the second thing that comes to mind is really recognizing the moral issues or the legal issues and not being afraid to put your foot down and say, hang on a moment, potentially this is unrealistic, or potentially to manage your expectations, this is actually how it's supposed to be. And for example, the employee that works at both firms or both companies, that was potentially a moral issue given that conflict of interest. We wouldn't be afraid to highlight that in that moment, just so that we can manage expectations moving forward.
Yeah, and I guess going back to your point about like being able to trust your partner on online and things like that, having a teamwork situation online is quite difficult. So how do you make sure that you're not like interrupting each other or jumping in when the other person wants to talk, or like interrupting the line of questioning and you want to move on to a different issue?
I think this is one of the opportunities actually where Zoom has kind of improved it a little bit, in that you're able to chat virtually and type with each other over either the Zoom chat or in a Google Doc separately, like you kind of saw how Harry and I structured it. I would suggest a Zoom chat might be a bit easier because you can privately message and everything's done in that one platform, compared to having to move backwards and forwards between that and Messenger or something else like that.
But on top of that though, in the circumstance that I have accidentally interrupted Sarah, it's more than okay for you then to just apologize and let one of you guys speak as well, because it is quite normal. It is a bit awkward to navigate such competitions online as well, but being courteous, having and demonstrating respect is always key in navigating those really awkward situations.
Cool. Another question is, how do you note take while listening to your client as well as responding to them?
Yeah, so how Harry and I have kind of navigated this is we generally try to do one or the other. So when I'm note-taking, Harry will be asking questions and I'll be detailing what has been said. And then when I have questions, and I'm speaking, Harry will be the one who's taking down the notes, and we have them all shared on that Google Doc like I showed previously, so that you'll be able to see, what exactly has been happening, and we'll write questions for each other as well. And it's just something to moderate in terms of our teamwork. And it really shows in terms of online teamwork, if you can bounce backwards and forwards and be very seamless with your transition, and having like a shared document where you're both working in that kind of capacity really helps with that, because it means that you'll be able to see what each other are going to say next, and in terms of what kind of questions you're going to ask next, and balance out that questioning as well.
And I think it comes more with practice as well, given that Sarah and I are at a stage now where we're comfortable just to dot point and take brief notes of what's been said. And sometimes we like to bold some key words that we think are legal or moral issues. And then based on who reads it, we'll jump in and really try to hone in on that particular issue as well. But it comes with practice, and it comes with understanding both your styles, but being able then to bounce back and forth is really crucial and key.
Yeah, definitely agree. And I think being online obviously offers an opportunity to try something new as well. Something that you wouldn't normally do face to face. And I guess if you're really stuck in a negotiation, what are some general questions that you should ask if you don't know what to ask?
Yeah, so Harry and I, whenever we're really stuck and we're not sure what to ask or where to go, or the client has just dropped something on us, if we can't ask a question about what the client has been talking about, we'll generally deflect and ask, what are your general goals and expectations? What do you want out of this interview? And that's often something that's really helpful and really useful, because at the end of almost every single client memo brief that's given to the clients, it will detail what they want. So it will detail the client wants to get A, B, and C. And if you can just straight up ask them and say, what are you looking for? Like, what are your expectations out of this? It's much easier for you to be able to get out that information. So like today, we saw Paula really, really wanted a restrictive injunction. And that was made very clear from the start, but also when we were asking those questions, what were your expectations? And she was able to very clearly answer that.
Very adamant.
And on top of that as well, sorry to interrupt, Alison, but you can also ask clarifying questions as well. So you could demonstrate you're listening to them by reciting facts and just confirming whether or not that is to be true. And it gives you time to think as well as in terms of the timeline about how the events have led up to this particular issue, and then how can you then move forward with your line of questioning.
The timeline is also a good one to ask as well. So we have a particular fact scenario where there's a lot of moving parts and something has happened a couple of months ago, and then now there's something else, and then there was something else that happened previous to that. A good thing to do is just to draw it out in front of you and say, okay, so we understand 6 months ago, this is the case. Is that correct? When they've clarified yes or no, you move on. 4 months ago, this happened. Is that also correct? And you just go through that timeline, and that will also help you get your head around what exactly has been happening, and the timeline of events, which can often be really important in terms of for things like restrictive injunctions or things like restraining orders or any of the other orders that you'd want to make from a court, because they will often have timelines and restriction periods placed on them.
And that then also allows the client to know that you have been listening to them, and it gives them an opportunity then to add on anything that they have missed out on as well.
Mm-hmm. So if they say, actually, that was actually this also happened in between that, you'll be able to catch that information and place it in your timeline, which makes it easier then later for you to be able to address any other questions that they have.
Sounds good. That's all we had for the submitted questions. If anyone, actually, one thing that does pop up is you are required to do a self-reflection after the client interview. What does that look like, and how do you structure it?
Harry, do you want to take this?
Yes. So in terms of the client interviewing reflection, you actually get 5 minutes after your client interviewing for you two to debrief on how you guys went in terms of addressing the needs and expectations of your client. And how we like to address this or approach this is actually to go through the marking criteria and really just go step by step in terms of one, the working atmosphere of the client. And I can't really remember from the top of my head, Sarah, so maybe you can jump in.
Sure. And then I think it goes into client goals and expectations, and then legal and moral ethical issues, your discovery of the client's story, things like that. Just really walk through them and say, what did you do well? What didn't you do well? So for example, something that we could say is, we did well in getting out Paula's issues and being very upfront with that. And I think we got the entire story out of that. But in terms of dealing with the client, that might not have been as good because she was very confrontational, and highlight why and her concerns, and highlight how you could have managed that better, how you did manage that, and anything else that you would do in future preparation or future, if you had to redo it, how else you could do better in that sense.
No, I definitely agree as well. I think that being able to know your strengths but also your weaknesses are signs of good reflections. And being able to tell the judge how next time you can improve is key.
Sounds good. Well, if there aren't any further questions from the audience, I believe that concludes our demo client interview for this semester. We do really hope that you sign up for the client interviewing competition, and if you've done it before, there's also the senior category, and also the wide range of competitions we have on offer, so contracts moot, criminal law moot, and the negotiations competition. So if you're looking forward to competing, good luck. Wish you all the best, and we look forward to seeing you in the competition scene.
Bye.